Welcome to our town hall with Chief Judge Glenn Kelley. We thank you for taking the time to join us for this important discussion about the state of our circuit. We encourage you to send questions, comments, or concerns in the Q&A feature. I will start by briefly introducing Chief Judge Kelley. After a long and successful career in private practice for over 20 years, Judge Kelley was appointed to the circuit bench in 2006. His term as the Chief Judge of the 15th Judicial Circuit began in July 2021 after former Chief Judge Krista Marks retired. Judge Kelley, thank you for being here with us today.
Pleasure to be here.
Okay, first, tell us how the transition has been for you from former Chief Judge Krista Marks, who had been our Chief Judge since 2017.
Well, the transition itself has been fairly smooth, primarily because of Judge Marks. After I was elected as Chief Judge, very soon thereafter, Judge Marks began to include me in weekly meetings with Barbara DeWicki, our trial court administrator, began to involve me in some of the decision-making processes that were involved as Chief Judge. And so she really smoothed that path. Although I will tell you, once you get in the seat, there are things you cannot anticipate, things that do occur. And so the transition itself has been fairly smooth. We have a very, very good administrative team here that has made it a lot easier because of their professionalism. So the whole transition has been smooth. Now, the issues that come up and the change in job function from what I was doing obviously can be somewhat dramatic. But in terms of the transition, it's gone very well, thanks to former Chief Judge Krista Marks and the very good court administration team that we have here.
A lot has happened since you became the Chief Judge. Can you tell us a little bit about the state of the circuit?
Sure. I mean, we began by talking about the transition. The first thing that obviously happened, my term began July 1st, and by the end of July, we were now in another COVID spike. And so that's the first thing that had to be addressed. I think the last time there was a town hall meeting like this with Judge Krista Marks was in June. At that time, we thought the pandemic was kind of in the rearview mirror. That turned out not to be the case. And so the first thing I had to deal with was what do we do with the Delta variant? And obviously we were going through a tremendous spike at the end of July and into August. And so we had to amend our administrative order with respect to emergency powers, had to adjust that, place mask restriction back in place. One of the challenges there was that because we thought, everyone thought in May and June that we were probably through COVID, a lot of the emergency orders initially entered by the Supreme Court had been vacated and changed. They still have an emergency order in place, and we're operating pursuant to that order. But we had to scramble a bit because all of the safety protocols and procedures that were set forth in those prior orders had basically been vacated. And so we didn't even have the authority initially to enter a mask mandate, to require social distancing, which didn't prove to be necessary this last time around. But in any event, we had to kind of scramble to get ourselves back in a position where we could deal with the variant with different administrative orders in place. And so we had to go through that and then continue to operate the court system, which I believe we successfully done. What it did require us to shift back to many of the things we were doing remote. We had shifted back to doing live, and we had to kind of move back to it remote. And so our emergency administrative order basically gave the various trial divisions and trial courts the ability to conduct remote proceedings unless it was a criminal case where there was confrontation clause or defendant's right to presence. We gave discretion to the various judges to conduct things remotely. And then fortunately, we've kind of come out of it, although we're not sure what the future is going to bring. I think overall, we're continuing to do well. We're trying jury trials. We kind of measure jury trials in terms of numbers since recommencing jury trials in November of last year. Since that time in circuit court, we've done like 218 combined criminal and civil jury trials. County criminal has done over 100. And so we're continuing to conduct jury trials, try to come back to some sense of normal as best we can, but still conducting a lot of things remotely and keeping our eyes on obviously the Omicron variant coming forward. One of the challenges we're having right now, I'll just tell you up front, there may be some questions about how things are going in particular divisions, but one of the challenges we have right now is that we have a lot of vacancies in key positions, and we're not able to fill them. That's a challenge right now, particularly with regard to case managers. In the probate division, for example, we're down 2 case managers. We have in the main courthouse, basically 1 case manager doing the work of 3. And it's not that we don't get qualified applicants, we get no applicants. And so we can't fill those positions. Due process, we have digital court reporting. We have 6 vacancies out of 14. We cannot fill them. And it goes across the board. We have difficulty getting law clerks. With all that said, our judges, JAs, and staff are working very hard, and I think we're continuing to make sure that everyone has access to the courts, but it's presenting some challenges because it puts additional work on existing staff in order to function. So we have challenges. Those are challenges being shared not just by the court system, but by everyone in terms of employment. I'm not sure why that is, whether it's a factor of COVID or can be blamed on COVID, I don't know. But it's a challenge, and so we're struggling with that. But I think we're doing well. We're continuing to move forward with jury trials, with hearings, and I can tell you this: the judges and JAs are working extremely hard.
So let's talk about the most recent administrative order 12.515.6-11/2022 regarding COVID-19 health and safety protocols and operational measures. This is the administrative order that basically said that masks are no longer mandatory as of November 15th, but they are still encouraged if you are unvaccinated, and that social distancing is no longer mandatory since November 15th, but it is still encouraged if you can, that the law library and the depot rooms are now open. And there's a portion of this administrative order that many of our members have had a question about. And I know that you and I have also talked about this. So there is a portion of it that states that individual judges, and it actually says judicial officers, so I'm assuming it's the magistrates too, are encouraged to enter standing orders delineating which type of proceedings will be heard presumptively in person and then presumptively remotely. Are the judges or magistrates all issuing these standard or these standing orders?
A direct answer to that, I do not believe all have. Maybe the word encouraged needs to be changed to the word shall. I'm not sure. I know that this can be an issue with members of the bar when they're trying to figure out what they are doing in front of various judges. I have considered in collecting some information that we could post on the website, which would give you basically a cheat sheet as to who's doing what presumptively in person versus presumptively remotely. This is something I think I'm going to have to look at more closely going forward. Obviously, the word is encouraged. There's not a mandate there, and some divisions have done that, although candidly, some divisions have not. And it does create that level of confusion. Obviously, the order setting hearing should always specify whether it's going to be a Zoom remote hearing or whether it's going to be in person. And you can always contact the judge's office. But I do agree that perhaps we should do a better job of basically telling the bar how we're operating across the board. So I would say that I've got some people who have been encouraged and have done it. I've got some folks that have encouraged and have not done it. But it's certainly something I think is worthwhile looking at more closely.
There's also a recent administrative order 2.402-12.21 that deals with jury panels. And can you just update us? Is there anything that you want our attorneys to know about that recent administrative order?
Well, I guess the first thing I would say is from the point of view of the practitioner, from the attorneys, it really doesn't affect you much. What that order does, I discovered that the panel size administrative order that we were operating under was basically 15 years out of date. It referenced a 1990 administrative order by the Supreme Court setting standard jury sizes, and a procedure was adopted based on that for ordering jurors internally. And essentially, the most important part of that was that over a certain size, an enlarged panel required chief judge approval, and then we would try to figure out with the jury office, how much can the jury office handle in any particular day. When I discovered that we were out of date, I obviously wanted to update the AO, and I did, and the AO is based on a 2006 administrative order by the Supreme Court, which updates the standard panel sizes, but if you look at that order, you'll see that they probably don't really reflect the reality of what a modern jury trial looks like. We usually use more jurors than are even set forth there. But what it does do is it creates a table. The Supreme Court AO creates a table for increasing or enlarging that panel size. What I did is I took that administrative order from the Supreme Court, used their standard guidelines, but then gave our jury trial divisions the discretion to basically add to that up to the maximum allowed under that Supreme Court administrative order, which is basically plus 20, and do that without my office's approval. Above that, it's the same thing you have to do, or had to do before. You have to get approval for an enlarged panel. But that's really more, it really affects us internally more than it does members of the bar. I mean, the judge has to go through certain protocols in order to get an enlarged panel. It really affects that. It really gives a little more discretion to the jury trial divisions as to how many jurors they can get without having to come through my office. But from the perspective of the practitioner, it really won't have much effect at all. It's really the judge internally operating with me and operating with the jury office.
Okay. And there's been another big change in our circuit. There's a new general counsel. Can you tell us about the new general counsel?
I can, Michael Bonin. We're very happy to have him, but he's not new to the circuit. He did start in, I think November 1st was his start date here as general counsel. As everyone knows, April Bristow was appointed to the county bench, and I'm just thrilled to have her as a county court judge. But she was also a big loss as general counsel because she was extremely good at it. Fortunately, Michael Bonin, a law clerk here before, and one of our attorneys that April worked with for a number of years. And so we were able to lure him back. He had gone to private practice, but we were able to lure him back to take this position. And we're extremely happy to help him. So basically, he was able to hit the ground with his feet running because he's familiar with the system. He's worked within the system. He knows how we operate. The judges know him and respect him. And so it's really been as good a transition as you could possibly hope for in that position, because it's an extremely important position to the circuit.
And as you know, there is a very important report that has just came out in November. The Judicial Management Council Work Group on Improved Resolution of Civil Cases issued its final report on November 15th, 2021. If any of our members need a copy of that report, feel free to email me. Judge Kelley, is there anything that you want to share with our attorneys about that report?
The main thing I want to share with everyone is pay attention to that report. The recommendations that are being made in that report are significant in terms of the way you practice law. It's basically a complete rewrite of the rules of civil procedure. I do not know whether all of the changes are going to pass or not. I do know that this is something that Chief Justice Kennedy is very interested in, and it's likely that many of the recommendations being made within that report are going to be adopted. And it is going to change significantly the way you practice law. Basically, the main thrust or impetus for the rule change is the idea that lawyers need to move cases through the system more quickly and more efficiently. and not have cases drag on for a significant period of time. And you will see that those rules are designed to do that. I mean, just give you one example, and I know this is dramatic, and whether it survives, I don't know, but we're all familiar with the concept of you set a case for trial when it is at issue. These rules provide the case can be set for trial whether it's at issue or not, and should be set for trial within the guidelines set forth by the Supreme Court, which, as we all know, for a general track case, 18 months. And there are significant changes to the discovery rules. There's significant changes to the rules relating to the filing and hearing of motions, giving judges the discretion not to even have hearings with respect to motions if they do not believe are necessary, putting significant requirements on attorneys to have discussions before the motion is filed or set for hearing. Some of the things in there require that certain hearings be set within a certain period of time. The most important message that I can give to members of the bar is pay attention to what's happening, because you don't want to wake up one day and realize that all the rules have changed and you're not sure how to practice law anymore in the state of Florida, because it's that significant in terms of the rules of civil procedure. They are significant changes. If you want input, obviously, you know, as a bar association, the Florida Bar is going to be solicited for their input. Chief judges have already given their input in terms of a letter to Justice Kennedy. It is being vetted. It's not like the differentiated case management, which is just going to fall out of the sky, which it did. But it's being discussed, but in some form, it's going to go through the Supreme Court and it's going to be adopted. I just don't know what that form is going to be.
Okay, so still on that report emphasizes differentiated case management. And I know you just talked about it, and I want to emphasize that there were 2 administrative orders that our circuit put into place. It is 3.107 and 3.108. And that was after the Florida administrative order from the Supreme Court that basically said we had to have some type of case management plans by, I believe, April of 2021. My question for you is, based on those administrative orders and what we know so far about how the case management plans are working in our circuit, do you think it is productive? Is it helping?
Well, it's too early to know whether it is helping. I think in the future it will. I think prospectively, I mean, this is not something we were planning to do absent, Supreme Court intervention. But most of the studies that you look at will tell you that some form of differentiated case management does make a difference in the timely processing of cases and is effective in moving cases forward. Candidly, the difficulty we have right now is the way that this was presented to us is we were given, not a lot of notice that it was going to happen. And when it did, it required a lot of work to bring cases into compliance. And what I mean by that is that the reason we have 2 administrative orders is one deals going prospectively from April 30 forward, and the other order deals with what's already happened. And when you're dealing with those retroactive cases, you might imagine, in circuit civil, 18,000 cases. You combine county civil, you got over 36,000 cases. That order required that we have a case management order and plan in place in every single one of those cases. And so that has been a monumental task for our judges and our case managers. Our case managers, the limited resources we have had to focus on that and to try to bring us into compliance. And so that's been difficult. Now, going forward, it's going to be easier. And I think going forward, it probably will pay dividends. It's just a little hard right now when you're in the process of trying to get everything in place to be in compliance with the mandates of the Supreme Court to tell anyone how it's working. Obviously, we're getting it done. Our judges are working very hard to put those case management plans in place. It does work better if we get cooperation from the bar, because our administrative orders require attorneys to meet and propose and agree to a case management order. And when you do that, it saves judicial labor and it brings us into compliance with the Supreme Court guidelines. So ultimately, I think it's probably going to pay dividends. It's just a little hard now because we're kind of in that situation where we're just trying to get in compliance with all those retroactive cases. It will be part of the work group on improved case management, resolution of civil cases. It's part of that. My feeling is it's probably going to become even more specific when those rules are adopted. In other words, each circuit has had the opportunity to kind of create its own orders and its own way to manage the situation. I think there's going to probably be a uniform order that's being used once the rules are changed. And so we're probably going to move to even a different look when it comes to differentiated case management, but it's here to stay. And I think in the end, it will pay dividends, but it's like anything else. You've got to learn how to use it, take it seriously, and work through it. And I don't think we're there quite yet. I think we're still trying to figure out what's it all going to look like and what's all going to happen, going forward.
Is there anything that you're hearing from the judges about what they would like our attorneys to do to help with the case management plans and making all of that work more efficiently?
Absolutely. Do what you're required to do. I mean, our administrative orders require that the attorneys meet, confer, and agree to a case management order. And if you do that, everything is done at that point. We get a case management order in the file. The deadline set forth in that order may have to be amended as you go forward. There's no doubt about that, but there's a case management order and plan in place. The difficulty is when you don't do that, then it first requires case management resources, because we have to have somebody go through the files and identify those cases that are not in compliance. And then it's going to require additional judicial intervention, because the judge is going to have to, either enter their own plan, which is, labor intensive, or set a case management conference, bring you in and set a plan. And so the more folks will just upfront, bite the bullet, look at it. And I know it's hard to agree on these deadlines, and I understand. I mean, lawyers disagree. But just get something in place and get it into us, and at least narrow the areas of disagreement, because that's the biggest problem when we're going through all of these various cases we have. We have to pull out the ones that are non-compliant and then bring them into compliance. Well, compliance requires a case management order, and so it's very labor intensive. And I can tell you, it's taking a lot of the judges' precious time to go through this and to be entering orders, and it's very labor intensive. So yes, to the extent you can help, you help by doing what the administrative orders require you to do.
We have a question from a member on the topic of the case management plans. Should a notice of readiness for trial still be filed in light of differentiated case management plans? Or, in other words, how does a notice of readiness for trial affect the case management plan?
Well, first, yes, the direct answer would be yes, you would still want to file a readiness for trial, because that's the mechanism by which, at least for now, until the rules get completely changed in 18 months by the Supreme Court, at least for now, that's the mechanism that's going to trigger the trial court to set the case for trial. But here's an interesting thing I want to add to that. The way that our administrative order is set up, one of the ways that you can avoid having to go through a case management order is to set the case for trial, because the trial order will take the place of a case management order. So if we already have a case with the trial order in place, there's no need to do a case management order. And so it's important. A lot of judges tried to go through and set as many cases for trial that were ready for trial as an alternative to setting a case management order, because then you've got a trial order that's giving you a trial date. All the deadlines that are normally in those trial orders are in those trial orders. But you still need to file them, because many of the case management plans, they may not be specific with respect to a particular trial date. They may set a time, 18 months from now on general track, but it's not actually on a docket. So you still need to submit your readiness for trial, trigger the trial court to go ahead and enter a trial order. And then basically the trial order is going to dictate how the case proceeds. It's going to supersede essentially the case management order, because it's now set for trial.
Okay. Going back to the final report on the resolution of civil cases, there's another part of that report that really emphasizes these clearance rates. And I'm sure most of our members will be reading this report and they will have some questions about how our circuit tracks our clearance rates and how those clearance rates may have been affected by COVID. Can you share any information with our members on that?
Sure. Clearance rate, tracking clearance rates actually is not something new. I mean, they have tracked clearance rates in Tallahassee for a long time. They gather data from the clerk's office and input that into their own systems, and clearance rates are something that's been around, for a long time. I know our own clearance rates historically have looked very, very good. Typically, and I'll talk about COVID in just a second because they have affected the clearance rate. Typically, our clearance rate in almost all divisions is in excess of 100%, which is what you want. You want, as many cases cleared as are filed. So when you hit 100%, you're clearing, one for one the cases that come in. Typically, we exceed 100%. During COVID, we fell behind a little bit. Obviously, the clearance rate was not as high, although interestingly, and it all depends on what period of time you want to look at. So, for example, if you look at from July of this year forward, our clearance rate is well in excess of 100% in most of our divisions. However, if you back that up to say March of 2020, when COVID really started to affect things, overall during that period of time, our clearance rate would be a little bit below 100%. It would be in the 90s. In some cases, I don't think any of it was in the 80s. I think it was still in the 90s. So historically, this has been tracked. It's something that will continue to be tracked. Some of the reporting requirements within the work group on improved resolution of civil cases, will not be popular probably with the courts because it goes down to the level of individual judges. But they basically have that information now. It's just a matter of how they use it. And going forward, there may be more emphasis on it just because of differentiated case management and the emphasis that they now have on closing cases. But we've always had a closure rate. And like I said, candidly, historically, individually with our judges and collectively, when we're not in COVID, we've always been very good.
We got a question from a member related to this, and he or she is asking whether attorneys' clearance rates are also tracked, or is it only the judiciary? My understanding from that report is it's about the court. Not
I'm not aware of all. That'd be an interesting statistic to keep. But no, I don't think there's any statistical analysis done of individual attorneys. It's all just a matter of clearance rates within the courts by division and by circuit. So the individual attorneys, they're not tracked in any way that I'm aware of.
Okay, now we're going to move into some questions we've received about hearings. And obviously, there's a lot of complaints about special set hearings and how long that is taking. But more importantly, I want to talk to you about a recent issue we've heard about UMC hearings. So we have a member who has waited between 4 to 8 weeks just for a UMC hearing. And his question is there anything that can be done to have the civil judges open up more slots for UMC hearings?
Well, short answer to that question is yes, the judges can always enter with, the UMC is now scheduled online as special sets are, although it doesn't have the same requirements. Obviously, the notice requirement is 5 days, and it's a different type of hearing, but it is done through what we call OLS. So it is online services that you use. When you when you're setting up your particular UMC calendar, you can put limits or you can have unlimited. So in short answer to your question, can more cases be accommodated? Yes, you can open up those limits. And that's up to the individual judge to do that. Candidly, I'm not aware of a division where it's taken 4 to 6 weeks to get a UMC. That concerns me because I'm not aware of that much delay. UMC normally does not take that long. As you know, most UMC, if not all right now, is completely remote. It's done through Zoom. Not many divisions are doing it in person. There may be a few doing it in person, but that's one area where everyone agrees that remote is a great tool. So I'm not aware of it taking that long. That would concern me if that's the case, if we have divisions that are taking that long. I don't know whether that's in the general civil division, whether it's in a family division, whether it's in a probate division. I don't know what the particular circumstance is, and maybe after this is over, you can send me something more specific about.
Yes, it is circuit civil, but I'll send you a more specific email about
Yeah,
that.
I mean, I'm not asking to call out any particular judge. I'm just saying, is it in a particular, is it in circuit civil, or is it because generally I wouldn't think that would be the case. 4 to 6 weeks, and there may be circumstances that are affecting that, in terms of schedules that we're not aware of. So there may be something, it may be a statistical outlier, but I would hope that would not be the case across the board.
And I heard you mention UMC hearings by Zoom. We actually had a question from one of our members just now. Will non-evidentiary hearings continue via Zoom?
Well, the answer to that is likely yes, but there are some issues going forward that we'll have to address. I mean, I get more questions, as you might imagine, on remote hearings and Zoom and the future of Zoom and the future of remote hearings. I mean, I would suspect that they're in some form here to stay. There does have to be some rule changes at the Supreme Court level. Keep in mind, right now, we're still operating under emergency procedures. I mean, it's scaled back. We do not have the ability to do masks or social distancing, and a lot of the health protocols have been scaled back, but we're still operating under an emergency order. And those emergency order, or that emergency order, suspends a lot of the rules that apply with respect to in-person hearings versus remote. And so we'll have to see whether those rules and those emergency rules are going to stay in place. But I suspect in some form it's going to go forward. Evidentiary. Now the question was non-evidentiary. In non-evidentiary, I think probably it will. But just that what that's going to look like and what uniformity we have with respect to that all has to be worked out. But I think everyone has seen the utility of Zoom and that it does have a place. The big challenge, I think, for the court system, not just in the 15th Judicial Circuit, but throughout the state, is defining what that role is going to be. Because, there is something to be said for being in court also. We do have a courthouse, we have courtrooms, our judges are here in person. And so we do have to strike that balance. And so exactly what that balance is, I think is going to be one of the challenges that we have as we come out of COVID. Hopefully we are, but as we come out of COVID, we're going to have to face that and decide exactly what it should look like going forward.
Related to Zoom, we've had a number of questions from our members asking how they can force in-person depositions and live mediation. Many attorneys feel that depositions and mediation aren't the same over Zoom, especially long depositions with a lot of exhibits. Any input on this?
Well, the direct question is, how can you force? And the way you can force is to file a motion with the presiding judge. That is an issue that's left to the discretion of the presiding judge as to how a deposition should occur in a particular case, or how mediation should occur in a particular case. And there's good reason for that. Cases have to be looked at individually, and circumstances have to be looked at individually. So there may be circumstances where it's justified because of some overarching health concern by one of the participants, or there might be other cases where there really is no justification other than people want to do the convenience of a remote proceeding. But that's something that really is left to the individual discretion of each trial court judge. And so if the parties, obviously the first thing you do is try to agree. If you can't agree, it's like any other issue you have to bring it in front of the presiding judge.
Similarly, this is the second part of this question. At what point will it be mandated that unless there is a true medical issue, depositions and mediations live by default, unless requested by the party and granted by the court? Is there a way to craft an administrative order that would at the very least suggest that live is preferred and leave of court is required to go back to Zoom on mediations and depositions as the default?
Let me address the administrative order, because I think within the question, that's what really is being asked. Can we craft an administrative order that basically creates a situation where presumptively all depositions are in person and presumptively all mediations are in person? Short answer to that question, I believe, is no. And the reason for that is that administrative orders can be used essentially to determine how internally we're going to conduct proceedings. For example, our AOs have dealt with when it's appropriate for a judge to conduct a hearing remotely or in person, but that has to do with in-court proceedings. When you're dealing with depositions outside of the courthouse and you're dealing with mediation outside of the courthouse, you're dealing with enforcement and interpretation of the rules of civil procedure. That's an area that individual trial court judges have the final say. I mean, in other words, it's not the proper subject of an administrative order. There are lines that we don't cross with respect to, administrative orders, and we like I said, we can deal internally with how we hear things, within what circumstances, the trial court judges should presumptively do things in person, and under what circumstances they should presumptively do things, remotely. And we can do that, and that'll probably change as we go forward. We're still operating under an emergency administrative order, so there is a lot of discretion left to the trial court judges with respect to proceedings. But outside of in-court proceedings, with respect to depositions and mediations that are governed by the rules of civil procedure, that is an area that the trial court judges have absolute discretion and they get to decide. And candidly, there's a good reason for that, as I just said. I mean, it's an individual, and I think probably you will find that our judges have an answer to what they believe presumptively should occur. I mean, I think they believe either that presumptively it should be in person or presumptively it should be remote at this time. Most probably think it should be presumptively in person, but I don't want to speak for our trial court judges. But the way to basically end any dispute about that, if you can't agree, is you just have to go in front of the particular presiding judge. It's not something I can legislate.
Okay. Talking about administrative orders and systems and procedures, is there a way to create a better system for judges to be able to rule on the papers so we don't have to wait for the hearing time if we don't want a hearing? Well, first of all, you can agree. The first thing to do is, if you agree that a hearing is not necessary, all you have to do is tell the presiding judge you don't need a hearing. The parties agree to do it on the papers, or to rule on the papers. And I am telling you right now, I can't think of a single judge that wouldn't take advantage of that. I mean, setting hearings and scheduling hearing times and being able to get to hearings is one of the most challenging things that our trial court judges have to face. They have limited time and resources, and the more they can do on the papers, I'm sure they would welcome that. So the first way to do it is by stipulation. Beyond that, I think what's interesting is that some of these rule changes that are coming out of this draft report contemplate that very thing, contemplate using, motions as a vehicle for, basically allowing the judge to determine whether or not a hearing is even necessary, and whether it's something they need to hear oral argument on. So there is a way to do it. I think the way to do it is through rule change, much like, everyone's familiar with the federal system. The federal system, it's, you get a hearing if the judge says you need a hearing. Whether it's going to go quite that far with the rule change, I don't know, but the way to get that done is with respect to a rule change. There are some circuits, I think, that have experimented with that through administrative order with respect to motions to dismiss, for example. I believe there are some circuits that have adopted a protocol whereby when motions to dismiss are filed, they're reviewed by the trial judge, and they are either ruled on the paper, basically just on the papers, or the judge thinks the hearing is necessary. I think at the time that was done, and I'll have to frankly research that a little more closely, there was some question as to whether that could be done by administrative order, but I have seen circuits that have done that. I think for a while the 19th was doing that. I'm not sure whether they still are or not, but there was some question raised, is that within our authority to do that? Because, we can't
What we can't do by AO is trump the rules of civil procedure. They come from the Supreme Court, but there is a way to do it. It's changing the rules. And I think it's something, frankly, that's coming, and it's probably something that's needed.
We have a question about Judge Cohen and Judge Easy. So is there a time frame for how long Judge Cohen will cover Judge Easy's division, or is it open-ended at this time? And is there any update on his health that can be shared?
Yes and no. I do not feel comfortable sharing any medical information with respect to Judge Easy specifically. I can share with you that Judge Easy and his family have come to the difficult decision that he is going to retire. And so Judge Easy will not be returning to the bench. That's relatively new news. I just shared that with his colleagues last Friday. So Judge Easy, after a very long and distinguished career, both at the state attorney's office and as a county court judge, has decided that, just based on current conditions, that it's time for him to retire. Judge Cohen is working in the division this month. What we're probably going to do next month is either have Judge Cohen or another senior judge again continue to fill in until we have an appointment to fill Judge Easy's position. We're not exactly sure when that will occur. Obviously, that's up to the governor when he receives the letter, and how quickly he gets the J&C together and how quickly he acts on their recommendations. But frankly, it's with great sadness that I announce now to the bar what I announced to his colleagues, is that Judge Easy has made that difficult decision, that it's time to retire, and he's not going to be coming back to the bench.
Wow. We're going to switch topics and move to some probate questions. Why is there now a 3 to 4 week wait to obtain probate letters of administration when for the past 30 years they have been available within 48 hours of submitting the order and letters?
Well, part of the answer is personnel. I'm not sure that fully answers the question. I will tell you this, that probate is something that I have focused on recently. In fact, I was meeting with our probate administrative judge, Judge Laura Johnson, last week, trying to figure out ways to assist and streamline the system. Part of our problem is what I mentioned at the top, is that we are missing key personnel that are used to assist judges in moving cases. Letters of administration would be one example. They have to go through the whole checklist of what's required before the letters are issued. We have case managers that assist us with that. We're missing 2 case managers at this point. We've not been able to fill those positions. As I mentioned, in Maine, we're basically, I think Maine and North, we're dealing with a situation where one person is doing the work of 3. And she's doing a great job. She's working extremely hard, and the judges are working extremely hard. But there's only so much they can do. And the other thing, just to understand, with the combination of family division with the probate division, the workload on our 9 judges that are doing probate and family combined is extremely heavy. It's I don't want to be melodramatic, but it could be described as oppressive at times, because they're dealing not just with typical family and probate matters. They're dealing with the domestic violence injunctions, which come in daily. They are working extremely hard, and they're frankly underwater. And when you add to that the fact that we're missing key case managers and personnel that assist the judges in doing their job, it can result in a perfect storm. It just slows things down. I will say this, it's not a problem that we're unaware of. As I said, I've had discussions with our administrative judge in probate already. We're looking at ways to improve it to the extent it can be improved. But it's certainly not something that we want to continue if we can find a solution. We're looking at it, and we're going to do the best we can, but that's the best explanation I can give you. I can't explain in a particular case, whether it was kicked back because it was missing something and then it comes back in and has to go through the review process. I know that does occur. But, you know, in an overall general sense, I can tell you that we're missing key personnel and our judges are just overwhelmed at times.
We just had someone ask, for the future, will the probate and family law divisions continue to be split divisions with judges handling both probate and family law cases? So I think they're asking, could there be a change?
There could be. That could be a whole hour discussion in and of itself, but I'll try to give you the short version of it. That's one of the first things I looked at when I became chief judge is trying to look at ways that we can separate those two divisions. And part of the difficulty in that, I mean, can it be done? It can be done, but part of the difficulty in that is the way that this all came together. The reason they're together is basically a workload issue. And our family law judges are just so overwhelmed that if we were to basically take away a couple of the judges assigned to family/probate and have them only do probate, the remaining family law cases would go to the family law judges that are still there. And the numbers would just be so high that they probably couldn't support them. I've looked at other little creative ways we might be able to do it, where we're, you know, basically going with, you know, instead of having you know, a one-on-one relationship between probate and family, that we cut back on the number of probate judges, but have them do only probate and add another family law judge. It's a very complicated issue in terms of workflow, and it's something we've looked at. Short term, I wouldn't look for it to happen. Long term, I think it's something that's still, you know, in the discussion stages as to how we could get there. What I really need are a couple more circuit court judges. If you give me that, I can do a lot more, but unfortunately, I don't see that happening anytime soon.
We have a question about why it is so difficult for the courthouse to hire staff. And I know you and I personally talked about this. Can you share with the members some of what you shared with me?
Well, I think there's a couple things. One, it just seems to be the environment that we're all in. I don't know. I've talked to, you know, Virginia Baker over at the county, who's in charge of the county. They have difficulty, although probably not as much difficulty as we do. It just seems to be, everyone goes out to a restaurant and sees help wanted signs. What's the same as, it's the same, you know, at a different level in the court system. I think part of it is just the environment we're in, but a bigger part of it, frankly, it's difficult, is we can't pay enough. I mean, our starting salaries are set by the state. They're set, you know, by category, and we do not have the discretion to exceed those. And the starting salary that we're offering for a lot of these positions, people just aren't going to work for that. And it's something that we have to address. It's something, I'm on the Trial Court Budget Commission statewide. It's been discussed there. It needs to be discussed more. It needs to be discussed with the legislature because they create positions, but they create positions at a pay scale that we just can't attract folks to take the job. And this is statewide. This isn't just the 15th Judicial Circuit. Miami-Dade is in even worse shape than we are in terms of getting people. And you got to imagine, cost of living in South Florida is different than cost of living in the Panhandle, but yet the jobs they pay the same. And we just can't attract people at that financial incentive level. It's just not enough. And until that changes, I don't know how it's going to get better, but it needs to get better because it really is significantly affecting court operations. We don't have support.
Okay, we had a member ask for the report. Just remember, if you want to see the report, please just email me and I will email it to you. So Judge Kelley, we appreciate you being here with us today. We appreciate all of your time. If there's anything you need from any of our members or the bar, please let us know. Any final remarks?
Well, I would make one final remark with respect to the report. Save yourself some effort. The report goes on for maybe 80.
300.
Yeah, it's a 300-page report, but it goes on and on and on and on about the reasons for this and the reasons for that, which is all important historically. But if you really want to get to it, do what I did when I sent it to our judges, just get to the rule changes. There are amendments, you know, they use the typical, you know, They strike through what's being changed and bold what's being added. And that's, just take a look at that. You can read the entire report if you like. You can look at the footnotes at the end. You can look at the reasons why, but if you really want to get a flavor for what we're talking about and how different these rules are going to look, I think it's 80 or 90 pages back. Just skip to the bottom line. Look at those rules, and you're going to see that there are a lot of changes coming. Other than that, the only closing remarks that I would have is I do appreciate the opportunity to speak. I mean, I think this is good. I think it's good to field questions. You have raised some issues with me that I probably can't directly answer when you ask me, why is it? Because I don't run each of the divisions that you're asking about. I don't know specifically. But when members of the bar have concerns and raise those concerns with me, then I can certainly go back to our judges and say, is this an issue? This is something that's important enough that members of the bar are asking the question. So if it's important enough for people to be raising their hand and asking the question, then it's important for us to take a look at it and see whether we can come up with a more specific answer or solution as best we can. So I do, even though I guess I will take the brunt of some of the criticism if there's shortcomings with respect to the court system, I do appreciate hearing those concerns, because the only way I can address those concerns, and the only way our judges can address those concerns, is to know what your concerns are, because they're interested in knowing too where can we do better. So I appreciate that feedback, and any other kind of feedback that you want to bring through the bar to me is welcome feedback.
We wish you and all the other judges happy holidays.
Okay, same to you. I guess maybe the next time, I don't know whether we're going to continue these or whether we're going to actually start. I know the bench bar is supposed to be in person, which I'm looking forward to.
In person.
So I don't know whether we're going to continue to have some sort of Zoom town hall or get together in person. Either way, I'm happy to participate.
Thank you so much.
Okay, thank you.
All of our members, happy holidays.